couple of other important things to note, again, which are very much relevant to our things in the news. The court has held that a sitting president is immune from civil damages for official acts unless Congress says otherwise and creates a statute in which the president could be liable. And the rationale for this, the court suggests, and if you think about it, it's probably a sensible rationale. You know, there's lots of decisions that the president has to make, and if it's possible that any private citizen could sue the president for negligence or something like that because of an official act, that could lead to a flood of litigation. Now, a counter might be, well, kind of the doctrine say it's a negligence claim. I mean, proximate cause, the fact that the president makes some decision about some foreign policy that has a ripple effect that, you know, affects the economy or affects, you know, my livelihood in some way, it probably would be fairly easy to say, well, there's no proximate cause there. But nevertheless, cases would go on, you'd have to adjudicate them, and the court has said, official acts, no civil liability. What about unofficial acts? And unofficial acts is the infamous Clinton v. Jones case. So I'll show you a couple of clips about the background of the alleged assault in Clinton v. Jones, and then we'll talk about the case.
There's a Shakespearean dimension to the whole Clinton impeachment saga. It grows out of the Paula Jones incident in 1991.
I want my child to grow up in the America I did. I don't want her to be part of the first generation of Americans to do worse than their parents did. I don't want her to be a part of a country that's coming apart instead of coming together.
It was May of 1991. Bill Clinton had just flown back from Cleveland, where he had given this rousing speech to the Democratic Leadership Conference that essentially solidified him as the front runner for the Democratic nomination. And when Clinton flies back that night, he's pumped. And it's the very next day that he wants Paula Jones up in his hotel room. He sows the seeds right there at a moment of one of his great triumphs for what became his greatest disaster.
Paula Jones had been an Arkansas State employee who had an encounter with then Governor Clinton, the Excelsior Hotel in Little Rock.
I mean, sweet, honest, country girl, not particularly sophisticated.
Well, on the day of May 8th, Trooper Ferguson approached me and handed me a little slip of paper. And he told me that he used the word Bill, would like to meet with you up in this room number. And Mr. Ferguson said, it's okay, we do this all the time. I was very excited the governor wanted to see me. I was, who wouldn't be? And I thought, well, and when me and my friend had talked about it, we thought, well, we might could get a job.
I am going to talk to Paula right now and ask her to give you kind of a blow-by-blow account of what transpired in the room.
I'll just put it this way, that he presented himself to me in a very unprofessional manner, and I would call it sexual harassment.
It was only years later, when he was president, that she came forward and accused him of a Me Too moment, before there were Me Too moments.
Well, he tried to pull me over, and he put his hand up my leg, and he told me how he liked the way my curves were, and he liked the way my hair went down to the middle of my back.
He starts moving in on her, fondling her, telling him he knows her boss.
He walked over beside me, and before I knew it, he had dropped his pants.
And then, you know, his famous Cary Grant moment.
He exposed himself, and he asked me to kiss it.
She recounts how she resisted and said, I'm not that kind of girl, and nothing happened.
It was just humiliating for someone of that nature. So you're supposed to trust somebody like that.
So President Clinton argues on the basis of Nixon v. Fitzgerald that he should be immune from this civil suit by Paula Jones, and the court disagrees. Justice Stevens says the Nixon case does not provide any basis for immunity on unofficial acts, and no one argues that this alleged assault on Paula Jones while now President Clinton was governor of Arkansas is an official presidential act, and there's no debate about that. No separation of power issue. The judiciary hears civil cases like this all the time, so that's not a problem. Justice Breyer concurs and says, yes, I agree, there's no absolute immunity, but let's just note that the trial court has broad discretion to schedule proceedings so that they don't conflict with the president's duties, and in fact, even the actual trial of the case could be postponed if the trial court wanted to do so until the president is out of office. Now, you've probably heard in the news a lot of discussion over the past year or so about the question whether a sitting president could be indicted for a criminal offense. So we know that a sitting president cannot be sued in a civil case for official acts. We know that a sitting president can be sued in a civil case for unofficial acts, although the proceedings could be managed in such a way that discovery or other things are delayed. We should note, however, even on that front, that in the Jones v. Clinton case, in the Paula Jones case, President Clinton did give a deposition and was required to give a deposition in that case. But we've heard a lot of question about can the president be indicted for criminal acts while in office. And as you've heard during the course of the Mueller probe, there is a Justice Department policy against indicting a sitting president. But that is simply a matter of Justice Department policy. We don't have a decision from the Supreme Court on this question, and I would suspect that the Supreme Court would say that a sitting president, if the president committed a crime, could be indicted for the crime, and that, again, it might be possible that the case might be managed in a certain way given the president's official duties, but it would seem highly unlikely that if the president is accused of a serious crime. I mean, the proverbial example, of course, is President Trump's quip during his campaign for the presidency that he could shoot somebody in the middle of the street and the voters wouldn't care. And whether that's true or not, if he in fact shot somebody in the middle of the street without, a proper reason to do so, self-defense or something like that, and it was an act of manslaughter or murder, I have very little doubt that the president could in fact be indicted for that and convicted for it. It would be an interesting constitutional question about could that proceeding be delayed or should it be delayed? Could the president then, if convicted, be incarcerated? I presume that if that in fact happened and the evidence was that clear, that there would be impeachment and agreement in Congress about impeachment, but who knows? And it would be, I don't want to say an interesting thing, but kind of a curious thing to have to test. Our last piece is, in fact, the standards for impeachment. So take a look at the impeachment clause, take a look at the standards and the discussion of this in the casebook. When we meet in class, we will actually spend some time talking a bit more about the historical precedents for impeachment and the current impeachment proceedings that are going on in the House and the question of President Trump. But I'll leave that for what should be a really good discussion for us on Saturday.